morning, everybody. We are here for our latest and greatest Ask the Agent Live. Today we have Nicoletti with us. I am Kelly DeLucia, as you all know. And I would love to introduce Al, and I would love for him to share a little bit about his background. He's an attorney. He's going to share a little bit about what he does, what his firm does, and then we will just discuss probate, which is our topic for today. So you inherited a property, now what? All right, Al, so tell us a little bit about your background.
Thank you, Kelly, for having me. Thank you, Christina, the Welch team, for having me. Again, my name's Al Nicoletti. I'm an attorney at the Bushman Ahern Persons and Bankston firm on Jacksonville Beach. A lot of our practice surrounds probate, the simple, the complex, a lot of the estate planning, like the wills, the trusts, the power of attorneys, and then a lot of the real estate litigation when things get a little bit tricky between property disputes. And a lot of my background started with a lot of foreclosure defense. Oh. When I had jumped into real estate, we were kind of almost at the end of this foreclosure boom.
So we had a lot of that in the mid-2000s.
Yes.
Okay.
And there was just so much case law that was coming out. So I really dove into foreclosures and somehow jumped into probate.
So the litigation side kind of came first.
Yes,
okay.
Litigation and a lot of the walking into court came, and it was a real experience to do that down in Miami. Oh. That's where I first started. You know, they threw me in with the wolves. So.
Lots of cranes down there that were no longer building properties, right?
Well, they're still standing, but I don't think anybody's doing anything with them. There's no liquidity going in. But naturally, with the foreclosures, I figured out that there was something with probate. Sure. Because I always have an adage. I say, really, there's only 3 reasons somebody didn't pay their mortgage. They forgot to pay, they can't pay, or they're dead. And so that's a big concept that we're running into as we get to this new generation of 2020, 2030, 2040. People are getting older. People are owning a lot of properties. A lot of the baby boomers own real estate.
Right, yeah.
So it dawned on me back when I was in Miami. I was like, there's a real niche here. There's a real niche with probate. And I knew a lot of the myths and nightmares that a lot of realtors and investors, they hear the word probate and they start like backing away, referring it out to another realtor.
Right.
And I don't know why, but I think I figured out that you got to take it head on, and there's something to be said about problem solving with probate.
Right.
Yeah.
Do you find that now, especially in Jax, so Jax Beach is where your office is located, do you find that you're doing a lot more planning so that the probate process is easy? I guess before we go into that, I should dial back a bit, and I should say, you know, what exactly is probate? You know, what happens? What is the definition of the word probate for all of our viewers out there?
So I like to break this down into like this crayon magic marker version of probate. All it is somebody was on title. So on the deed, there was some kind of title. That person owned real estate. They died. And in order to get the title to the heirs, Florida says you know, and the title underwriters require this process to get the title to the heirs. Right. That court process is probate.
That is the definition of probate.
That's it.
So there's one mystery solved already. So what the heck is probate? We've got that down.
Right. So it's not as complicated as people make it sound. And there's a way to get it done fast. There's a way to make sure it's done efficiently, and just making sure everybody's on board with some kind of real estate transaction. But one of the other things about probate is, what is it? You need it because of title insurance.
Correct.
You can't close on that property. The underwriter of a title company will not insure a buyer's policy without it.
So, for instance, I inherit a property from a family member. Maybe it was deeded to me in a will. What is my first step? What do I call you?
Well, I would hope so. Like, one of the first things you want to do is find out if there's a will. I always ask, is it an original will?
Okay.
You want to make sure it is an original, because then therefore it is a will.
Original meaning it has been inked. Okay, not
inked.
It has been changed 12 times.
Right.
Still the original.
Well, you always want to make sure that there's not going to be one that's like, 2011, 2012, 2013. But always finding out, is this the original will?
Okay.
Because in Florida, if it's a copy of a will, it's presumed that there wasn't a will, and therefore you have to prove that there was.
That there was something, okay?
So, yeah, one of the first things you want to do is find, come to me, a lawyer, and let's figure out what we can do to help the family make sure that the property gets transferred to the heirs. Maybe there's some bank accounts. Maybe there's some money in a brokerage account, a Roth, an IRA, where there wasn't a beneficiary designation. Because there are some times where people on a bank account will name their kids as a payable on death.
Okay.
That would avoid probate.
Okay.
But a lot of times people don't name their children or anybody on a bank account payable on death beneficiary.
So let's dive into that.
Sure.
So while we're talking about, avoiding probate, if I inherit this property, there's no way that I can put it on the market and sell it without going through that process, right? Because
Correct.
I don't technically own it yet, even though I've been named in the will, unless, is there another scenario?
So there's a couple ways where probate is avoided, and that is where the property's titled in a trust. It was conveyed by a Lady Bird deed, life estate deed. A lot of people are always like, what is that? But it's basically somebody had the life tenant title and then named two people that upon death, the interest automatically, without probate, transfers. Maybe it's husband and wife.
Okay.
But if you have the will,
right,
you have to go, will does not avoid probate.
Okay.
That's a big point. It steers where probate goes.
That's a great definition. I think it's very helpful.
Yeah.
It's like your blueprint.
Right. It's the roadmap. It tells you who is supposed to oversee the estate. It says who gets the personal property, who gets the Rolex, who gets the diamonds, who gets the other property involved. And it just lays it out. And it actually says, in the event Kelly shall predecease me, it shall go to her heirs. Okay. It just lays it out. So yes, you go to the lawyer, you figure out what everybody wants to do, find out what real estate there is. You want to find out all the assets up front.
Does probate encompass other assets other than real estate? A car, something else, anything? The Rolex that you mentioned.
Well, bank accounts.
Okay.
Brokerage accounts, Roth. If you don't have a named beneficiary designation, you need to then transfer it over and use the probate process.
So do all of those have to be done separately, or they're all done through the same process?
They're all done through the same process, but what's happened sometimes is they didn't realize there was another bank account after it was closed.
And you're like, what's this?
What
everybody likes to have extra money.
Sure. And then you just have to reopen the estate. But a lot of times people don't have wills.
Oh.
And so you have to think about what happens in those scenarios.
Okay.
So I inherited a house, there's mom and dad had no will. Where are we thinking things go? And in Florida, there is a statute that says where things go.
Okay.
It says if there's a spouse, okay, you find out if there's a spouse, there's no spouse, are there children? Okay, so you have to keep going down the line, children, grandchildren, and then you actually go up. If there's no children, spouse, you go up to parents.
Huh.
So you have to start thinking through, like, who's in my line? Am I only survived by siblings, no children, no spouse? Those are the people that are going to matter about where probate goes.
Sure.
So Florida says that.
So do we need to, as a real estate agent, I'll shift gears to the real estate side. Do I need to get very specific with somebody? Let's say somebody comes to me, because most of the time it's the heir or whoever thinks they might be the heir to this property. What are the questions that I would want to ask them? A lot of times we, to help steer them through that, because most of the time I would say, people say, I have this property, now what? And do you know somebody? Do you have a probate attorney? I've got to go through this process and I'm not really sure what to do, but I need to sell it tomorrow. So what are the things, I can't, there's a mortgage on it. There are things that are happening. that they don't want to assume responsibility for,
Sure.
even though they've inherited this property.
Sure.
So they want to get it up, they want to get it live, they want to get it on the market. What are the things that I need to ask up front?
Well, first of all, if there was a mortgage and the mortgage was with the deceased person, the deceased was on the note, the family has no responsibility personally with personal liability as far as any debt owed. That debt only related to that person that was on the note.
Right.
But in terms of that mortgage being still against the property, as an agent, one of the things realtors and investors overlook sometimes is knowing what's on title. The title commitment is so important. A title search, title commitment, I'm more of a fan of the title commitment. It tells the bottom line to know what's going on the property.
Okay.
But always you want to find out, find out the story, Kelly. Always ask what the story is. Like, who's around? Is there the spouse? Are there children? Is there a will? Find out as much as you can, big picture, without it coming across as like a pointed question, or this person's getting specific. You always want to be authentic and gentle with people, and just finding out the big story. A lot of people love talking about the story, and they get too into their background and childhood with some of the heirs, but always get the story of who is around, because that matters on the realtor investor side. That matters about who's under contract.
Who has to sign the listing agreement, the purchase and sale agreement?
Well, the listing agreement doesn't necessarily have to be signed by everybody.
Oh, okay.
The contract is definitely the thing that you have to be aware of who has to sign. And not getting complicated, but if you run across one of these homes, another big question you want to ask is, was this where that deceased person lived and resided?
So their homestead.
Right.
So tell us, how does that play in?
So you don't want to assume that it wasn't their homestead because they did not claim tax exemption.
Okay.
Tax exemption is not what classifies homestead.
Okay.
Where did they live? Is that where they lived? Is that where they resided? That plays a role, because if it is their homestead, you have to make sure you have all of those heirs in the storyline, whoever is applicable, on that contract.
That could be a lot of people in some cases.
It can.
And what if people we can't track them down? Then what?
So there are creative solutions to some of this stuff that would be a whole other segment.
Okay, part two.
There's part two. There's stuff called partition lawsuits where there's a forced sale, like the probate's done, title now is in 1, 2, and 3, 4, can't find 2. There may be a solution to figuring out a sale of the others. Maybe a quiet title lawsuit. That's a whole other ballgame.
A lot of ballbacks, got it?
But just know that there are possibilities to solving those problems. But most of the time, it doesn't happen.
Okay. So I'd like to remind everybody out there too, if you have any questions, maybe you're going through this, or you know somebody who's going through this, you're sitting on a property right now because you don't know what your first step is, shout out those questions to us. Comment. I'm checking our feed here to see what people are asking. And I want to ask this because it just popped into my head when you said, there could be 4 different scenarios, or, how do we get around that? So one term I've often heard in some of our transactions is, well, I don't know if I'm using the right, like a quick, fast track version. Like, I have all the things I need. This is from an attorney saying, we've got all the things I need. I think I can take this to a judge, and the probate process may only be 6 weeks long, whatever that may be. Like, how long is your typical process?
If it's not complicated, I can get it done in 2 to 4 days.
Okay, so what does that look like?
Way better than...
So 2 to 4 days, even better? It's like the Disney Fast Pass.
So what does that look like? That is making sure we have everything and all of the information. Knowing where the death certificates are, all the beneficiaries, knowing their mailing addresses, names, just having as much information as you can. Okay. Then knowing, the homestead is really important. Knowing what known creditors there are is important. And not to get complicated, but if the date of death was more than 2 years, you don't have to worry about creditors. The family doesn't have to worry about it.
That's new. All right.
Yeah.
Picked up a piece of info today.
You're welcome.
Well, many, but like that one really resonates for some people.
Yeah, because a lot of people are worried about the Discover card, the boat loan, and anything more than 2 years from date of death is they can't make a claim. They're not able to make a claim. That's important for heirs because if they own multiple properties and it's not just the homestead, the good news is they're going to get their money a lot faster than in a creditor period.
Right.
And I find that a lot coming into the office, that a lot of the probates have been more than 2 years. I don't know if that's just the sweet spot of when people are ready to do the process.
Emotionally comfortable, or
they're ready to sell the house.
Or maybe they have multiple people that had to come to an agreement, which can take time, right?
Correct, it can.
So what if you have tenants in common?
Okay.
And I passed away, but I had a tenant in common.
Sure.
Then what? I mean, is that different? Does probate work the same because somebody else owns part of the property?
So in that scenario, if you own it, Kelly, and let's just say John, tenants in common, and John dies, his interests, it goes down his line.
Got it.
Okay? So his half
is whoever is his named
is his heirs.
Does that piece have to go through probate?
Yes.
So that one half.
Yes, that has to go through probate.
One half. Who knew?
But if it's John and Kelly and the deed is titled joint tenants with the right of survivorship, and John dies, it automatically, with the recording of a death certificate, goes to Kelly.
And then I would the whole thing, huh? No.
But then if Kelly dies, it goes down your line.
My line.
Yes.
So if when people this is a little bit different, but when people take title on property, when they close, when they first purchase, are these questions that you think they should go through right then and there? These are life, estate law type questions. Are those things that people often overlook that could avoid maybe some probate unsureness in the future?
I think one of the best things a realtor or an investor could do is use some of the tools that are out there, like understanding deeds. The property appraiser's, main screen when you come across some of these property is not all accurate. What says John and Sally, you pull titles, John, Sally, Mike, and Larry.
Susie and somebody over there that no one's ever heard of, and the square footage and beds and baths are wrong too. So we know that there's a lot of errors on what the property appraiser records.
Right, but it's knowing and understanding the deeds.
Right, okay.
It's understanding following chain of title and like going from A to B, B to C. Knowing up front how things work in the chain helps you know where things are at.
Right. Okay. That makes a lot of sense. And I think that that's one thing that we often overlook as agents is, we don't ever want to be giving out legal advice, but partnering with the right people, partnering with yourself, so that as those questions come up, we can direct our customers to the right resources so that, they're getting, they're getting more bang for their buck. They're getting full service here. They're getting all of the tools that they need, and we can help direct them to the right person with the right qualifications to help answer those questions. So learning about this is extremely helpful for us. I'm sure everybody out there. If you haven't asked your questions, let me know. I've seen a couple that have been very close to what we've been asking. So good job, guys.
I'd also point out, Kelly, a lot of people, a lot of realtors, a lot of investors go through or have gone through some nightmare scenarios. Nightmare meaning it's taken 2 years, it's taken 3 years. This video, whether it's live or it's just replayed later, always ask the questions later to the Welch team, and they can always get back to me later and say, hey, somebody asked this like 3 weeks later, they just watched it now. Because there's no reason that a probate should take a year to 3 years. The only reason a probate should take a year to 3 years is something like I'm going through now, where there's litigation over the will, over like the definition of something.
Gotcha.
The only other reason is that somebody's not working the file, or maybe the property's just sitting around. I don't know. But it's good for the Welch team, it's good for me to understand what are those nightmare scenarios that you're running through?
Mm-hmm.
I'd like to know, because when I work a probate, I make sure we can get it done, we move it efficiently,
Sure.
let's move it along so we get them their money.
So moving things along, so if somebody came to us as a listing agent, as a real estate professional and said, I have this, I need to go through probate, but can I market it now? Is that okay? Can I market the property for sale even while we're still going through the probate process?
Well, you definitely want to find out from the lawyer or the probate lawyer where things are at. But generally, there's nothing wrong with listing the property, but the bigger picture is the contract. You're going to need everybody to even do anything with that property. And I don't do what you do at all. So I would say that leaving it on the market longer than it should is probably not a good thing either, because otherwise people are going to go, well, what's wrong with this property? Well, what's the backstory? But there's nothing wrong with listing it. But at the end of the day, there's a contract, and you're going to want to know what's going to happen with that contract.
That makes a lot of sense in many ways.
Yes.
So when you typically, I'll wrap it up with, I know we're getting close to the end of our time, but if you could just give everybody the short, sweet version of what we discussed here today and what they should do if they find themselves in this situation, what is the step 1, the step 2, the step 3, so that they can contact you and have that further conversation. What are the top most important things we need to do right away when we inherit a property or we might be faced with a similar probate situation?
I would say number 1, making sure there's going to be money, because if there's a short sale or a mortgage and there's multiple liens, there's not going to be anything to do. I mean, you're going to be either having to figure out with the title company how to get rid of the liens or the mortgage, and there's going to be no equity. So first of all, I would definitely say, if you're interested, find out the story of the family. But then once you got the story, you need to make sure what's on title. Super important, because if there's mortgages and liens, you're not going to have any room. Nobody's going to make anything from the deal. People have to be motivated to do the deal. Then it's finding and having them reach out to a lawyer that understands how to structure the probate, how to move the probate along, somebody that gets it, that's not going to delay it, that's going to just make sure everybody's kind of on board, and or if it doesn't, everybody starts
some equity in this home.
Yeah, once you start putting money on the table, everybody just starts, going, I think it's time we do this.
Probably causes more problems in some cases too.
Sometimes, yes, it does.
Well, speaking of money, let me ask one other follow-up to that. How much would the average, if it was an easy probate, let's say, how much would an average cost? Because I assume that those are upfront costs that people are going to need to pay for your services to actually go bring this in front of a judge.
Help, it is what it is. Those are costs. And so a simple cost probate for a summary is about $250. I would say if you have add a bank account, you're looking at $350. If you're looking at multiple properties, you're looking at $450 costs. And if date of death is within 2 years, you have to do the creditor period. So that's probably about total $575. Costs. But when you're looking at lawyer fees, each one depends on the amount of work I have to do on the file. Maybe if it's that easy, $1,500, $2,000, but
so get your ducks in a row, everybody, so that you can bring everything we need at one time, right?
Right, exactly. Well, if it's easier like that, but it never usually is. Like, I'm going through one right now in Seminole County, and I flat rate it, and I'm like, well, my time has been a little bit more than that. Because there have been 7 waivers, and it's just trying to make sure you get everything done. Follow up. I'm really good at follow up and communicating, and so people know that.
Well, then there's definitely value in that as well. So I took you off course. So we had step 1, step 2. Making sure the step 2 was making sure there was enough money involved in this process to get everyone on board. And what's the last step, and we'll wrap it up.
One of the last steps is just communicating and being authentic with the heirs. Nobody likes when people are pushy. They see right through it. They know that what you're caring about is the commission. What you're caring about is just the end and then dipping out on everybody. A lot of people know that. If you care more about helping them get what they need, and that shows, that's just going to make things happen smooth. But a lot of the times it's them thinking that the lawyer stuff is expensive, and sometimes it is.
Sure.
Sometimes you have large estates. It's almost like a realtor commission. We can get 3%. And a lot of times it's telling them, like, look, there's a way that we can get this done where with me I can wait for my fees at the closing. So it's almost like they don't ever have to pay anything.
Very
So just being authentic, communicating, super important with everybody.
Well, these are some great pieces of advice. I know that I've learned some things here today. I hope that everybody else out there did too. I want to say a special thanks to Al Nicoletti. I don't want to get your firm wrong. So with Bushman, Ahern, Persons, and Bankston Law Firm in Jacksonville Beach. So to all of our North Floridians, I should say, be sure to check them out. But sounds like you guys do work all across the state. So if you have family in other areas, and we are talking about family here, so definitely give a call. What's your phone number or best contact information and how they can reach you?
Sure. So best phone number is 904-246-9994. And my email is anicoletti, so ANICOLETTI at BAPBLaw.com.
We will put that all in the comments and the discussion board as well, so don't feel like, feel free to rewind and watch this as many times as you want, but we will make that easy for you. Thank you so much. It was a pleasure having you here today.
Thank you.
And thank you to everybody out there. Watch, share, and we'll see you next time.